topic of this discussion will be mental state of a defendant and the admissibility of that mental state in introduction as a defense to an offense for which that person stands accused. The courts of the state have held that diminished capacity, that is the capability of an individual to form the necessary specific intent mens rea to commit an offense, is not an affirmative defense to that offense. That the only time that mental illness can be supplied to a jury in making a determination as to whether or not that person could have a capacity to form a specific intent to commit the offense is when the individual pleads on the issue of insanity, or the insanity defense is the affirmative defense advocated by the defendant. There is, however, a line of cases that take a somewhat more narrow approach, and those line of cases deal with defeating the burden of proof of the prosecution in proving up each and every element of the offense that that person is charged with. There is a line of cases that suggest that mental illness can be used to, in fact, defeat the proof of the allegation of the prosecution in the particular offense. And I would suggest that rather than, for instance, if you don't have a case that bears fruit of a full-fledged insanity defense, but there are mental health issues that are abundantly clear, that you take an approach during the guilt or innocence phase and make every effort to get those issues before the judge or jury. The judge has complete discretion to allow that information to come in. Additionally, under 3836, we are permitted to develop the circumstances of the action, the circumstances between the victim and the accused, even the mental state and mindset of the accused at the time of the action that led that person into the criminal justice system. But the court also has the ability, as the gatekeeper, to, under 403, to determine whether or not the mental health evidence that is being proffered to defeat the theory of the state that this individual intentionally or knowingly committed this particular offense is able, under 403, the court must conduct that balancing test to determine whether or not that evidence is probative, and if it is probative as to a particular issue, that it is not outweighed by prejudicial impact, so that the jury is misled and confused, and the court can make that decision to keep that type of evidence out. The court has sole discretion to do that, and I would urge that the practitioner, when there isn't a full-fledged insanity defense available, to make every effort to produce that particular mental health evidence to a jury, and it will help immensely if not achieving a desired result in guilt or innocence, but can be used also successfully in mitigation, which leads me to my second topic. If you have an occasion to use this theory of mental illness to defeat the allegations of the state, I would suggest that you refer to Jackson versus State It was decided by the Court of Criminal Appeals and significantly on a petition for discretionary review. Was delivered April the 13th of 2005. The petition for discretionary review number is 1655-03, and it's excellently written, and I think draws a very tight but bright line between what the issue of diminished capacity not being permitted and the issue of being able to get mental illness in if you decide to do that, short of invoking the insanity defense.